The Victorian Farmers Federation has put together this video to provide information to farm businesses about their obligations as employers. Farm businesses are able to employ different types of employees depending on the situation that works best for their business. These employees can be classified as either permanent or casual. It is important to make sure you understand the difference between these to make sure you are following the law and that your employees receive their correct entitlements. Permanent employees can either be classified as full-time or part-time. Full-time employees work a 38-hour week, for example, Monday to Friday, 9 AM to 5 PM. Part-time employees work regular set hours that are less than a full-time week. For example, instead of working 5 days per week, the employee may only work 3. All permanent employees are guaranteed certain entitlements, including paid annual leave, parental leave and sick leave, paid leave for public holidays, paid long service leave, superannuation, and a minimum period of notice in the case of their employment being terminated. Part-time employees receive these entitlements on a pro rata basis. Casual employees can be used for short, irregular periods of work. A casual employee has no guaranteed hours of work, usually works irregular hours, does not get paid sick or annual leave, and can be terminated without notice unless they are covered by an agreement or contract stating otherwise. Casual employees are entitled to a higher pay rate than equivalent full-time or part-time employees. This is called a casual loading and is paid because they do not receive benefits such as sick leave. Casual employees are entitled to 2 unpaid days of carers leave and 2 unpaid days of compassionate leave per occasion. They are also entitled to 5 days unpaid family and domestic violence leave per year and unpaid community service leave. It is important that your business keeps complete and accurate records about your employees. This is not only required by law, but will also help to assist your business if need be in the future. Under the Fair Work Act, you're obligated to keep employee records for 7 years. They cannot be altered unless you are correcting an error. They cannot be false or misleading. They need to be legible, and they must be in a form that is easily accessible by a Fair Work inspector. You must make copies of employee records available to them at their request. This also includes any former employee. Fair Work inspectors and unions may have a right to inspect these documents. In this situation, you should contact the VFF and we can advise on your rights and obligations. There is a range of information you must keep as part of your employee records, including superannuation, rates of pay, hours worked, and more. A comprehensive list of information that needs to be recorded can be found in the VFF Employment Handbook, which is available for VFF members to purchase. An employment contract is an agreement between an employer and employee and sets out the terms and conditions of employment. It can be written or it can be verbal. The VFF strongly advises that employers use written contracts for all employees. It is important that you and your employees understand that an employment contract cannot provide for less than the minimum entitlements under the National Employment Standards and any awards that apply. All employees are covered by the National Employment Standards regardless whether they've signed a contract. A contract cannot make employees worse off than their minimum legal entitlements. The VFF can provide advice and information regarding employment contracts and what minimum legal entitlements you must follow. For further information on workplace relations, call the VFF or visit our website vff.org.au.